Chief Justice, the Honourable Sir Gabuma Gibbs Salika and Lady Rosika Salil Salika, His Excellency John Kali and High Commissioner for Papua New Guinea and Madam Lavin Nama Very Kali, honoured members of the High Commission and Consul General of Papua New Guinea, His Excellency Mr. Vitaliano Gaspar Galadro Valencia, Ambassador of Peru in Australia and PNG, the Honourable Justice Jacqueline Gleeson of the High Court of Australia, the Honourable Justice Andrew Bell, Chief Justice of the New South Wales Supreme Court, and of course, the Honourable Michael Kirby. I also would like to recognise the Honourable Justice Paula Stawa and the Honourable Justice Laura Wawun Kuvi of the Supreme and National Courts of Papua New Guinea, as well as the Honourable Justice Andrew Kostopoulos of the Supreme Court of Papua New Guinea. Honourable Judges of the Federal Court of Australia, members of the Federal and New South Wales State Parliaments, Vice-Chancellor George Williams, Emeritus Professor Jan Reid, and of course the Somari Whitlam Australia scholars who are here this evening, members of the Whitlam family, and of course the board of the Whitlam Institute. Ladies and gentlemen, all welcome. We are honoured by your presence here this evening for this special address on legal pluralism in Papua New Guinea by the Honourable Chief Justice Sir Gabuma Gibbs Salika on the eve of the Golden Jubilee of Papua New Guinea's independence. Now, to offer a welcome to country, I call upon Michael West of the Metropolitan Local Aboriginal Land Council. Michael.
Thank you. I'd like to say Bojadi Gamarua, g'day everyone. How are you this morning? Or sorry, this evening. I'd had to have half afternoon nap, was a bit tired. Justice Salika, I'd like to say it's great to have you here on the land of the Gadigal people, one of the 29 clans of your nation. And we did have a little bit of a yarn just before about culture and how important culture is in both our cultural identities and who we are, and our connection in a sense with the top end there with the Torres Strait Islanders and the Papua New Guinean people, how they have that traded for a long time, which is great. And when I was thinking about that, I was thinking about the beautiful cockatoo that's in, do you know, because a picture of the cockatoo in the Vatican? Yep. It's great, isn't it? Almost 800 years. There's a picture of a depiction of a cockatoo that's in the Vatican. One can only imagine what the Pope and the Cardinals thought about this wonderful creature. We all know what the creature's like, don't we? Yes, very loud. Very intelligent, very cheeky, and very mischievous. And it has a lot of fun. When they get together, they're playing around and they like stripping the flowers off the trees, and they have their part to play. All the different animals have their part to play. And we were just talking too about traditional bark canoe. In Sydney here, it's called Narwee, and we actually have a suburb called Narwee out in southwestern Sydney, which is important, remembering all these wonderful names and that. And I was just out of high school 50 years ago, so I do remember when you got your independence, and I think it's important that we keep our culture going, and what that is very important to me and very important to you, I know, as we just had that little yarn. And I'm sure you're looking forward to, I know you guys up there are really looking forward to the NRL team. Yes.
I can't wait for it.
Yeah, I know you love your sport too. It'll be interesting to see South play your team. Aboriginal people are very passionate about South. The Rabbitohs, and we'll see how it'll go. I'm sure it's going to be a great contest. It'll be great. Bringing us closer together through sport, I think, is so important. And here where we are, obviously, we're on the land of the Gadigal, one of the 29 clans, as I said before. Out on that harbour, in Narwee, paddling across and looking at the other side of the harbour bridge, also known as the Coat Hanger, that is Camaragal country over there. Suburb of Camara is named after there. And when I'm out on the water there or near the water, I always think of barra. In our languages, we have rolling R's, so barra. look, Barra Marigal is where Parramatta is, and that's a clan out there. So I always think of Barra in its migration to Pacifica, where it does journey to our brothers and sisters, other brothers and sisters in Pacifica. And I always think of the beautiful whales in its migration journey, and they would come in here to the harbour, and they would go down to Gomera, also known as Darling Harbour, with their little calves and rest there. That's what traditionally what would happen for over many, many thousands of years, and they're totems. So what happens, they're protected, there's a spiritual connection, and they're family. So they know that they can come in here for many, many tens of thousands of years and they would be protected. And there was a whale the other week coming around, and he come around, and they were going around the harbour, and I was thinking, were they looking for, is there a latent memory passed down through generations, and they're looking for their place where they connect to for many tens of thousands of years? Because animals are smart, they are quite clever. Sometimes humans aren't, are they? We can be better. We need to be better humans when you think about it. And I'm thinking about all this rain that we've had. I was talking to some of the other elders, and I was thinking that I wonder if it's Mother Earth saying, look, please do better. I'm shedding some tears for her, for me, and also for humans, what we're doing to ourselves. And we need to do better. We need to do a lot better on this wonderful planet we all share as humans, and we can. And I love sharing our culture, our knowledge and our wisdom of First Nations from all around this wonderful world, because we have that total connection to Mother Earth and understand how Mother Earth is so important to us, and also things like our food is all part of cultural identity, and that's why I love sharing all the different foods and learning all the different stories. I'd just like to say on behalf, the support, we do take a moment of silence to pay respect to our ancestors, pay respects to Mother Earth, as our cultures require. And it's important that we reflect our journey right here, right now, and the 50 years that you have progressed with your independence. And I'm sure there's going to be another 50 years, going to be another great celebration of a centenary, no doubt. I'm not sure if you will both be there at that time. I'm in my 60s, so, but I'm sure the younger ones coming through will be, creating that further bond between our two countries. So I support we just have a moment of silence, pay respects to ancestors, pay respects to Mother Earth, reflect our journey, pay respects to all Aboriginal Torres Strait Islander tradition owners, elders and custodians of past and present, for looking after country, spirit of country, also paying respects to the Papua New Guinea elders for looking after country, spirit of country, maintaining your culture. It's so important to do that. And just reflect our journey right here, right now, in the 50 years of independence. So we just have a moment of silence and a moment of reflection. Thanks. To the south, we have the Georges River. To the north, we have the Hawkesbury, also known as Darubin. To the west, we have Nepean. These are the aquatic boundaries of the Eora Nation. On behalf of Metropolitan Local Aboriginal Land Council elders and members, welcome everyone here, especially welcoming Chief Justice Salika and Lady Salika, especially welcome you two to our wonderful country here. And we want you to have a safe stay. And I see that there's a lot of your other compadres, Papua New Guineans that are here, and others from around Pacifica.
Commissioners here too.
Sorry?
Our commissioners.
And your High Commissioners here. High Commissioner, especially about welcoming you too, and your partner. Sorry about that, I didn't know. Here, and I think, sharing our culture, having a yarn as we did before, is all about who we are as humans. And we want you to have a safe stay, safe journey back to your country, to your community, to your family, and enjoy your time here. And I'm sure it's going to be an interesting talk that we're going to hear tonight. Always was, always will be Aboriginal land, never ceded. Thank you.
I'll be exceedingly brief. When I was last here at the Whitlam Institute conference, I said I felt a bit like the Lord Chancellor in Iolanthe, who agreed to his own application to marry a ward of court, because what I was doing was welcoming people on behalf of the Federal Court and then thanking the Federal Court on behalf of the Whitlam Institute. But I'm relieved from the first of those responsibilities because next to me is Justice Stephen Burley. Justice Burley is the head of the court's International Cooperation Committee, which involves the responsibility for what might be described as the outreach of the court to a number of other courts throughout the world, with particular emphasis, of course, in our region. He has travelled to Papua New Guinea to meet the Chief Justice and has also been responsible for planning the Memorandum of Understanding between the Federal Court of Australia and the Supreme Court of Papua New Guinea. So, Justice Burley, you probably would have noticed from my countenance and my extreme youth that Justice Burley is older than me, and is the immediately more senior judge on the court. So please welcome Justice.
Don't you hate it that public records include your birth date? It's an honour to be here to introduce Sir Gibbs. He's a long-standing and valued friend of the Federal Court and of many other courts and judges in the Australian judiciary. I convey my best wishes and apologies of Chief Justice Deborah Mortimer, who regrets being unable to attend tonight. It's a singular occasion to be able to join together at an event organised by the Whitlam Institute to mark the occasion of the Golden Jubilee of Papua New Guinea's independence. That moment, the history records, was brought about in large part by collaboration between Sir Michael Somare, working with Gough Whitlam, who were determined to see the project through. Gough Whitlam later said, "If history were to obliterate the whole of my public career, save for my contribution to the independence of a democratic Papua New Guinea, I should rest content." I have a feeling that those in this room are very aware of other contributions that Gough Whitlam had to feel content about, but his statement demonstrates the importance of the moment for him. It's in this, of course, democracy never sleeps, and the birth of a nation requires nourishment. And it's in this context that it's a particular pleasure to be able to honour Sir Gibbs tonight, whose court has done much to ensure that from its early roots, Papua New Guinea could grow and develop as a nation. Sir Gibbs is now a towering figure in the Papua New Guinean judiciary, but his roots were local. He originally came from Kulale village in the South Fly district of Western Province, a region whose population provides a sample of the rich tapestry of Papua New Guinea's diverse cultures. He completed his legal education at the University of Papua New Guinea, gaining admission to the bar in 1979. His professional journey began as a state prosecutor, followed by service as legal counsel to the Ombudsman Commission, and later as principal magistrate in 1988. In 1989, Sir Gibbs was appointed as a judge of the National Court, a position that he has held with distinction now for over 35 years. I know that the Honourable Michael Kirby and my colleague Justice Nye Perham keep count of judicial longevity, and no doubt they are looking at your years with some envy. Indeed, Sir Gibbs is the longest-serving judge in the National and Supreme Court of Papua New Guinea. This tenure is not merely a number, it represents a career marked by deep understanding of Papua New Guinea's legal landscape, cultures and people. Sir Gibbs was sworn into the office as Deputy Chief Justice in 2009 and as Chief Justice in November 2018. Throughout his career, Sir Gibbs has presided over numerous cases of public interest and constitutional importance. He's been instrumental in shaping jurisprudence on matters critical to Papua New Guinea's development, including cases concerning leadership integrity, the misuse of public fund, and the enforcement of constitutional rights. His decisions have consistently reinforced the rule of law and affirmed the independence of the judiciary, often in challenging circumstances. He has overseen crucial electoral challenges, championed efforts to combat corruption, including his role in setting up the Fraud Court in 2013, and more recently urging lawyers to utilise anti-corruption laws, and has been a leading voice in advancing judicial integrity across the Pacific. In the middle of his many commitments, Sir Gibbs has found time to foster and deepen a long-standing and treasured relationship with the Federal Court of Australia. As a bit of history, this relationship began over 20 years ago with informal collaboration in the form of visits and presentations, and more formal ties were commenced in 2009 when our court signed the first of their 5-year Memoranda of Understanding on judicial cooperation. Since then, our courts have consistently renewed their mutual commitment, signing further agreements in 2014 and 2019, and most recently in February this year. These agreements, which have been facilitated by DFAT providing funds, but respecting the independence of the courts, have allowed us to refine and expand our cooperation, addressing critical areas of judicial capacity building and also practical matters such as commercial case management and court annex mediation. Our collaboration encompasses a wide range of activities that foster deep professional and personal connections. Their aim is to ensure that there's not only court-to-court collaboration, but also judge-to-judge collaboration, a relationship that ensures that judges in our two countries can get to know each other, form bonds, and learn from each other's experiences. Many of my colleagues over the years have enjoyed these interactions, perhaps none more so than Justices Collier and Logan, who since 2011 and 2013 have respectively been periodically released from federal court duties, not at all like being released from detention, to sit as judges on the Supreme Court of PNG. Amongst his many judicial commitments, Sir Gibbs has chaired the Papua New Guinea Centre for Judicial Excellence, which is an education institute that operates as an adjunct to the Supreme Court. I had the pleasure of visiting the centre a while ago and was introduced to the rich diversity of the administration of justice in PNG, a system that takes into account the traditional laws and customs of numerous diverse tribal groups within vastly different languages, geography, and approaches to the rule of law. The centre performs outreach into remote communities which struggle to obtain access to courts in larger centres, educating them on the constitution, civil rights, and the intersection between tribal law and Papua New Guinean common law. Consideration of those aspects of diversity among the Papua New Guinean population point to the challenges that the judiciary of Papua New Guinea faces and commend the work of Sir Gibbs in fostering a court that is one of the most trusted public institutions in Papua New Guinea. It is this diversity that forms the centrepiece of the presentation tonight, which is entitled Legal Pluralism in Papua New Guinea, and will include an examination of the respective roles of village, magistrates' courts, customary law, the Papua New Guinea constitution, and the common law system, a lot to synthesise. You may have gathered from my introduction so far that if ever there was a judge qualified to speak about legal pluralism, it is Sir Gibbs. Our gathering today, hosted by the Whitlam Institute in conjunction with DFAT and the Federal Court, is particularly significant. The relationship between Australia and Papua New Guinea is special, and we hold a common history, values, and an enduring bond as neighbours, partners, and friends. This event provides an ideal platform to celebrate the achievements of the Papua New Guinea Australia Law and Justice Partnership and to look forward to its continued operation. The topic that Sir Gibbs has chosen is particularly apt to highlighting the role that the Papua New Guinean judiciary has had over 50 years since independence in protecting the democratic processes that underlie the nation of Papua New Guinea and which forms a significant part of our common bond. In introducing Sir Gibbs tonight, we acknowledge his distinguished services to the Papua New Guinean judiciary and the efforts that he has made to strengthen the role of the judiciary in the Pacific region more generally. His address today is not only a highlight of this event, but a powerful symbol of the ongoing friendship between our people and our legal systems. His insights are invaluable, and we eagerly await hearing from them. Our Prime Minister said, after walking the Kokoda track with Papua New Guinean Prime Minister James Marape, that Australia will keep walking together with PNG, side by side, step by step. So too will our courts. Please join me in extending a warm welcome to Sir Gibbs Salika.
Thank you, Stephen. Thank you for the kind and warm introduction and for the welcome. Thank you, brother, for your beautiful welcome to your land. Yes, I value culture and custom very much too, just like yourself. Thank you. In February of this year, I was in Melbourne with visiting the Federal Court Chief Justice Deborah Mortimer, but she's not here today. I noted that. And then I met, I think, somebody from fellows from Foreign Affairs, and then they suggested to me whether I'd be prepared to come and deliver a speech here. I said, well, I'll await your invitation. And so the invitation followed me later on, and here I am. Some 10 months later, or whatever, 8 months later, I'm here. But thank you for the invitation to come and deliver this address. As you know, Papua New Guinea celebrates its 50 years of independence, political independence, on the 16th of September 1975. And I recall I was a first-year law student at the University of Papua New Guinea, 1975. And I think our High Commissioner, Mr. Kali, was doing his second year, because both of us had been at Sageri 2 years earlier, and then he came ahead to the university, and we came later with a lot of other students from that year. And well, the country was preparing for independence. We had obtained self-government, and were in 1973, and were now waiting for independence. And it so happened that the Labour government was in power then, and Whitlam, whose photograph I see here, he was present, and he was the one, and we thank you. And I want to thank members of his family that are here for giving us that independence. There was a push also to have independence delayed. Sir Michael Samaras said, "No, I'm not having anything delayed. I'm having my independence this year, in 1975," and he got it. And Gough Whitlam gave it to us. And so again, we thank you. All right. But today I want to begin by saying this. The Honorable John Faulkner, Board Chair of the Whitlam Institute, board members of the Whitlam Institute, including Justice Michael Lee, who is also a Justice of the Federal Court, Professor John Jurians, Director, Whitlam Institute, thank you for the invitation. The Chief Justice of the Federal Court, Deborah Mortimer, is not here. And to make a special mention of Justices Bernard Collier and John Logan, both of the Federal Court of Australia, from Queensland, who are serving at our Supreme Court and the National Court in Papua New Guinea, and they've been serving there since 2011. And the then Chief Justice Salamo Injia and I came here and signed the Memorandum of Understanding with Michael Black, and in 2011. And so since then, both Justices Collier and Logan had started serving in our courts in PNG. So they've been having dual responsibilities in Papua New Guinea Federal Court, and also in the Supreme Court and the National Courts of Papua New Guinea. So I want to thank the Chief Justice then, Michael Black. I met him in Melbourne earlier this year. He was there, and I thanked him there that it was through him that the MOU was agreed upon and signed, and so we thank him as well. And I also want to take a particular mention of Stephen Burley. Thank you, Steve, for your kind words of welcome again. My judicial colleagues from Papua New Guinea, Justices Kuvi, Justice Doa, and Justice Kostopoulos, who is serving in one of the most difficult parts of our country, in Tari, and that happens to be our Prime Minister's province. But he has been very brave to go there, and I didn't ask him to go there. He chose that place himself to go there. So we thank you. I had earmarked him for Enga, but he said, no, brother, don't send me there. Because I'm well known to the people in Enga, as I represent them in the Pogra gold mine litigation. So I said, okay, that's fine. We'll have you sent to Tari instead. So thank you, Justice Kostopoulos, for volunteering to go to Tari. Yes, and I acknowledge my country's High Commissioner, John Kelly, and his wife. Thank you for coming to attend this seminar. And the other Papua New Guineans who are among the crowd there, I see you there. Thank you for coming as well. And our Consul General, who is here in Sydney, based here in Sydney, thank you for meeting me at the airport, me and my delegation at the airport, and bringing us to and taking care of us since yesterday afternoon. Thank you. And I want to thank all of you for those of you who are here for attending this seminar. Thank you very much. I'm honored to be here with you to deliver this special keynote address to commemorate the 50th anniversary of the independence of Papua New Guinea and to celebrate the common goals of the Papua New Guinea-Australia Law and Justice Partnership. It is appropriate to be able to present on the topic of legal pluralism in Papua New Guinea, particularly as we are at this point in our development period post-independence, which took place on the 16th of September 1975. There ought to be consideration given to indigenous parameters when assessing or analyzing how law reforms in a country such as Papua New Guinea. It has also been argued by some that too much law may result in disorder. I reflect on the simplicity of life growing up in a village where most people are unaware of anything else outside of the village. And my brother Mike mentioned I am from the Torres Strait region of Papua New Guinea. On the border, I share my customary border with the Saibai Islanders and Dawan Islanders. So I'm directly opposite on the mainland side of Papua New Guinea. So yes, I'm familiar with that part of the country. Yes. Their reality is connected to custom and local culture. The indigenous way of doing things is what has been passed on from generation to generation up to today. This has translated today into the introduction of village courts, which have a limited jurisdiction but addresses most disputes throughout Papua New Guinea at the local level in the villages. Life in the village in Papua New Guinea, where people generally live, is based on custom and culture founded on indigenous ways. For thousands of years, this has been our way of life, and 50 years post-independence, most of our disputes are dealt with in villages through customary mechanisms that have been practiced over these years and for a very long time. And this is a clear example of legal pluralism that has evolved within Papua New Guinea. The indigenous culture and customs throughout Papua New Guinea have always been with us, and with the introduction of the common law through colonization, we evolved with legal pluralism. 50 years later, this is why the Constitution of Papua New Guinea, which underpins all law in our country, was relevant at the beginning of independence and is such an important guiding instrument to the regard for legal pluralism that exists. Section 9 of our Constitution of Papua New Guinea states that the laws of Papua New Guinea shall consist of this Constitution, the organic laws, acts of parliament, emergency regulations, and provincial laws, and laws made under or adopted by or under the Constitution, or any of those laws, including subordinate legislative enactments made under this Constitution or any of those laws, and the underlying law and none other. Now, the underlying law under our Constitution also includes our customary law. And so customary law is also part of our laws that we grapple with in our courts on a daily basis as well. The recognition of indigenous law within our Constitution is through the underlying law. In Schedule 2, Part 1 of our Constitution, it states, subject to subsection 2 and 3, custom is adopted and shall be applied and enforced as part of the underlying law. The acceptance of our founding leaders of the need to ensure that in addition to the reception of the common law passed on the rules and principles of the common law and equity of England at 16 September 1975, that our indigenous ways of doing things, and particularly our indigenous laws, were captured within the constitutional context as a significant milestone in our birth as a nation. The Constitution further indicates that the purpose of Schedule 2 of our Constitution is to assist with developing the indigenous jurisprudence. Such clarity of purpose provides assurance to the people of Papua New Guinea that our indigenous legal development has a place within the modern Papua New Guinea. This is true legal pluralism, putting academic theory to the practice. The constitutional provisions give legal pluralism standing in our society and statute, as is the case in the Underlying Law Act of 2000, that is the underlying law of Papua New Guinea, supports this proposition of inclusion of indigenous laws in application in PNG post-independence. In Madaha, Resena, Brau, Gaigo, and Igo Oala, on behalf of themselves and all other members of the Iduhus of Tatana village against the independent state of Papua New Guinea in relation to the Fisherman Island, it was held, and I quote, the prerequisites of formation of an appropriate rule of law as part of the underlying law under Schedule 2.3 of the Constitution are A, an inquiry into and proof by evidence of the existence of an application of any relevant principle of customary law, and B, whether the particular matter is inconsistent with the principles of customary law as found in accordance with Schedule 2.2, subsection 1 of the Constitution. This Supreme Court case resulted in the matter being sent back to the National Court to determine whether there was any custom by which damages could be assessed. It further indicates that legal pluralism exists for our indigenous people. Another Supreme Court case that I find interesting because it was a reference in relation to a question of law as to whether provocation can be a complete defense on a charge of manslaughter under Section 302 of our Criminal Code refers to indigenous jurisprudence. In PLAR number 1 of 1980, request by principal legal advisor on point of law arising in a case where a person tried upon indictment has been acquitted. Justice Wilson states this, and I quote, the Supreme Court has and should accept a special responsibility to assist in the development of our indigenous jurisprudence adapted to the changing circumstances of Papua New Guinea, end of quote. A further demonstration of how the Supreme Court has considered indigenous jurisprudence on its deliberations in PNG is in the National Court case of Kombea against Peke. It was indicated that custom could be pleaded to give effect as accepted in Schedule 2.21, subsection 1C of the Constitution, where an action in common law is commenced which is not a part of the underlying law. There are some particular there are some, particularly in the academia, who may prefer the view that custom and indigenous jurisprudential development in PNG has been limited, and this is as a result of the judiciary and the legal profession. However, there is sufficient empirical evidence to show that the village court and the Supreme Court use custom and indigenous law as sources of authority. In contemplating this topic, I am mindful of the opportunity to appropriately develop the law in Papua New Guinea. Section 5 of the underlying law act says, and I quote, Section 5, duty of courts. The courts, especially the Supreme Court and the National Court, shall ensure that with due regard to the need for consistency, the underlying law develops as a coherent system in a manner that is appropriate to the circumstances of the country. There is no doubt a lacuna in the actual development of the underlying law, and 50 years on as an independent nation, we have much work to do in this area. There is opportunity within the legal fraternity to assist the courts in rapidly and advancing the progress of the underlying law in Papua New Guinea. It means that in matters before the courts, pleading custom and ensuring that there is compliance with the underlying law are crucial to successful litigation. Even in observation, it may be easier to rely almost exclusively on the common law when looking at stare decisis and how it operates, and this is likely the reason why there are not more cases advanced on the pleading of custom and submissions. I will refer to a matter that I dealt with. Custom was pleaded in a matter that I was dealing with. A businessman had lost his property. His property, he had been running a club in Port Moresby in a suburb called Waigani, and some disgruntled soldiers who had been drinking at the club did some damage at the club, and a lot of damage was done. And so the owner of the club, he was from Mount Hagen in the highlands of PNG, and so he sued under custom. He pleaded custom that he sued the state, and he said, all right, your servants were involved in destroying my property, and by custom, because in custom, where a tribe or clan destroys another clan or tribe's properties, the entire clan is responsible. That's customary law. The entire tribe is responsible for the damage that they had caused, and therefore that custom with that tribe that did the damage, they must pay compensation for the damage they had done to the other tribe. And so this man pleaded custom in that regard, and so he took his actions in Port Moresby. And then I asked him, so yes, it is good that you're pleading your custom, but your custom does not apply here in Port Moresby, because your custom applies in Mount Hagen, not here in Port Moresby. So you want to go and practice your custom, plead your custom, plead it in Mount Hagen, not here. And so that's how I dealt with the matter. And he then took his withdrew his matter, and it went away. But that was how I dealt with his matter, because he pleaded custom, but because he was from another province from the Western Islands in Mount Hagen, he pleaded his custom in Port Moresby. Then I told him, you plead Papuan custom here. You plead Port Moresby custom here, not Mount Hagen custom here. Anyway, that's how that matter got resolved. The legal pluralism concept is not easy for many to understand, particularly when using the lens of individualism. PNG is a collective communal culture, and it is appropriate that the dialogue and intellectual discourse surrounding legal pluralism has prominence as we celebrate our 50th independence anniversary and look ahead to the next 50 years. Papua New Guinea academic Dr. Balkama is currently at the Australian National University. In his book, Rethinking Judicial Power in Papua New Guinea refers to the development of a homegrown constitution, which is distinct from the reception of many other former colonies. This terminology of homegrown reflects the legal pluralism that is associated with evolution as a country. In the state against versus Wantaim, I've got a citation there too. The Australian judge who sat on our bench at the time stated as follows: the Constitution itself is a truly autochthonous constitution. It derives from the people of Papua New Guinea. Papua New Guinea, it grew here and is given Papua New Guinea by her own people, end of quote. It is this recognition by Australia at the time, through your own jurists who adjudicated matters in Papua New Guinea, which supports the proposition of this indigenous system, which contributes to our legal system. For many persons outside of Papua New Guinea, it is a daunting, confusing concept and even comprehensible at times on how our legal pluralism exists in a coherent and stable manner, endorsing the rule of law. The existing legal forms has raised negative questions as to whether it detracts from the rule of law, while positive line of questioning prefers whether legal pluralism addresses the rule of law functioning in a situation where the other types of legal systems may not succeed. I contend that the Papua New Guinea experience dictates that our legal pluralism presents a fair and just way of ensuring that the rule of law is supported and functioning given the complexity and diversity of our society. In the matter of Yongo Mondo and the matter of Constitution Section 42, subsection 5, the National Court had to determine whether imprisonment was a valid punishment to pay a civil debt or judgment under the Village Courts Act. In this case, the applicant was before the National Court judge on a complaint that she was being unlawfully or unreasonably detained in prison. She was held on a warrant issued for 84 weeks imprisonment by virtue of an order of the Village Court at Dage Mitna in the Simbu province and endorsed by the local court in Kundiawa. This was in 1988. She had failed to pay compensation according to a village court order. In a village court, a complaint was made. In the village court, a complaint was made by the applicant's husband in 1984 that she had left him and returned to her village and was seeking a return of the bride price or some equivalent for the loss of his wife. It was assessed by the village court that she should pay him 840 kina, and the order for imprisonment was made some 3 to 4 years after this order for failure to pay. The National Court judge in his judgment stated, and I quote, "An order for repayment of bride price definitely cannot be related to Section 42, subsection 1b of the Constitution, an offence which she has been found guilty, nor to Section 42, subsection 1d relating to the commission of an offence. And neither can it come within Section 42, 1c, as the bride price obligation cannot be seen as an obligation imposed by law. It may be argued that it is an obligation imposed by customary law. Bride price and any repayment thereof is a civil obligation and in no way can be regarded as a criminal offence or involving criminal obligations or sanctions," end of quote. It is instructive to note that the learned judge opined that the higher courts were getting criticism that imprisonment for serious offences were not appropriate punishment in Papua New Guinea, and that the courts should be examining ways of addressing offenders aligned with traditional societal expectations and obligations. In this particular case, we can see the conflict of approaches of applying law in which there is legal pluralism. There are those who argue that constitutional democracy and legal pluralism are incompatible. The notion of legal pluralism functioning without endangering a democratic society does not suggest that it does not have the potential for issues. However, I am not of the view that it is incompatible with democracy, and the experience we have in Papua New Guinea suggests otherwise. I quote a federal court judge who also sits in our court in PNG, Justice John Logan, who said at page 18 Commonwealth Law Conference in South Africa that democracy is alive and well in Papua New Guinea, at times exuberantly so. This recognition of our reality further indicates that as we celebrate 50 years as an independent country, our journey towards a more fair and just society continues through our embracing democratic ideals. It is endorsed by a constitution that is unique in its attributes and supports the legal pluralism, which is foundation of rule of law conceptually. There are some academics who argue that legal pluralism exists everywhere. We know that the imposition of the English legal system around the Commonwealth created legal pluralism in our modern contextual form. It would have been preferred that if this legal pluralism was not allowed to exist, the indigenous systems would become extinct. The preservation of indigenous people in terms of culture and intellectual constructs are enabled through legal pluralism. However, there is a prevailing misconception that in our different systems which relate to custom, this has a connotation that is outdated or inferior. My intention in reframing this idea of legal pluralism and relevance in PNG is to demonstrate that without the existence of it, the loss of our cultural identity, customs, and dignity of who we are as individual cultural groups would have been lost. The rights of indigenous populations are protected through legal pluralism. It is this contemporary image of law that has been advanced by socio-legal scholars. It is a literature in a literature review of scholars on the subject of legal pluralism. Professor Gordon Woodman, who was a member of the Faculty of Law in Birmingham Law School at the University of Birmingham in the United Kingdom since 1976, and died in 2017 when he visited the University of Papua New Guinea in 1985, and presented a paper suggested that lawyers are of the view that the law is the law of the state. I believe that we can all agree that while this generally appears to be a reasonable argument within legal pluralism, we should consider customary law, rules and practices, and how they inform. In PNG, there has been a consistent effort by Australia to assist in our national development post-independence. Within the law and justice sector, most of the donor funding from international groups and non-governmental organizations who are also funded by countries such as Australia, New Zealand, and prior to recent times, the United States, focused primarily on the formal legal system. There is recognition through empirical data and studies that there is a need to do more with strengthening and supporting legal pluralism systems, particularly at the village court level in the communities. We know anecdotally that empirically that law affects development. In this regard, our courts with legal pluralism in place are challenged to adjudicate matters in a reasonable time to ensure that justice is done, which will contribute to certainty and reliability in effectively handling disputes between parties. The law of the state is embodied in our constitution in Papua New Guinea. There are many philosophers and scholars who subscribe to monism, which would be the opposite of our existence as a collection of indigenous people in Papua New Guinea, and would be in defiance of these things we know to be true in our past, present, and future. I am certain that the framers of our constitution envision that for generations to come in 50 and 100 years and beyond, the legal pluralism, which has meaning to how we function, will be a sustaining concept that binds us with our over 800 tribes and languages as a nation. Our society consists of so many different normative systems that allow us to be able to thrive, having done so for thousands of years. As a country who is encouraging more foreign direct investment, and where state stability and certainty are part and parcel of what investors expect, the legal pluralism that exists provides mechanisms and provides investors with an understanding of how to do business while navigating our various societal groups. Flexibility, while accommodating certainty in the law, affords opportunities and benefits for our people in PNG. Courts are often handling cases which address issues about legitimacy in relation to overlapping legal frameworks associated with legal pluralism. My presentation today has focused narrowly on legal pluralism in the PNG experience as a general construct. It is noteworthy that areas such as global legal pluralism also exist, which informs on international law. In examining PNG indigenous practices, the authenticity of many of these customs are not an issue because they are recognized within the cultural context and throughout rural communities. It is accepted that PNG as a country of laws has nearly all aspects of national life covered. Legal pluralism has buttressed this reality, and as we continue to progress as a nation, we have done well to improve our capacity to establish ourselves as a young and vibrant independent nation state in the global community. I thank you for sharing your time with me and allowing me to provide you with some context as the Chief Justice of Papua New Guinea. A pleasant day and a pleasant evening to you all. Thank you.
Chief Justice Salika and Lady Salika, your honours, many. High Commissioner Kali, it's a great pleasure to see you again as well. Distinguished guests, all, my name is Maurice Payne. I'm a board member of the Whitlam Institute, and it's my great honour to offer this vote of thanks to you, Chief Justice, for your excellent remarks, a fascinating and erudite exposition on the complexities and challenges of the Papua New Guinea legal system and legal pluralism in particular. Like so many of you here this evening, I'm a passionate advocate of the Australia-Papua New Guinea relationship, as His Excellency the High Commissioner knows well. Chief Justice, your presence here today, and in fact the stories that Justice Stephen Burley and you have both related about the connections between the courts in Papua New Guinea and Australia is strongly emblematic of that close relationship. In the 50 years since independence, much has been written about Australia and Papua New Guinea, but I think nothing exemplifies better or is stronger than our people-to-people relationships, which you have demonstrated here again this evening. That includes those formed in the Second World War. My father was one of those Australian soldiers. And through communities, through churches, through education, through parliaments, through business, through the judiciary, through the professions and through families. And as His Honour Justice Burley stated, it's a special relationship, and that is a very apposite description. And there are some overwhelmingly important tangible representations of the closeness of that relationship and those bonds as well. My experience, one of those is Bamana War Cemetery in Port Moresby. 3,824 graves, 3,300 of which at least are Australian. It is tended with care and love and respect by an amazing team of local Papua New Guinea staff. It's a place of immensely solemn reflection, some sadness, but also of beauty. And I am ever grateful for those Papua New Guinea staff who care for the soldiers who never returned. You may not know, but I want to talk to you as well, just briefly, Chief Justice, about an extraordinary place in Port Moresby, for which I have a great love, the Papua New Guinea National Museum and Art Gallery. And ladies and gentlemen, if you haven't been, you must. You absolutely must. Australia supported the establishment of the then National Museum in 1975, 50 years ago. We supported its refurbishment in 2018, and I was honoured to be there at the reopening with Grand Chief Sir Michael Samare. It is, without exaggeration, a stunning, evocative display of the myriad cultural, artistic and historic aspects of Papua New Guinea that make your country such a fascinating and beguiling place. And I'm very proud of Australia's support for that. Michael, you would love it. The connections across the Torres Strait are there in front of you in every gallery. It is amazing. Chief Justice, thank you for your words, your contribution in particular to the Australia-Papua New Guinea relationship, for your steadfast leadership in the legal development of your nation, and for being here to mark this very important 50th anniversary of the independence of Papua New Guinea. It's a great honour to meet you. Thank you.